Let's go ahead and set up. You ready, sir?
I am ready, Judge.
All right.
I see you're giving me 20 minutes.
Yes, sir.
Wow.
Would you like this?
That's a lot.
Don't feel compelled to take it off.
You know, it's not mandatory.
Direct your attention to the Attorney General's office.
My name is Bard Rockenbach. I represent Gem Broadcasting, the appellant in this case, and Joe Farish. This case involves two contracts to sell two radio stations.
I'm going to interrupt you just so that you can focus on when you relate the facts to the point. Was Ms. Holly Hawkins paid the monies for attorney's fees and for her damages for her sexual harassment or sexual EEOC violation case?
It was an employment discrimination case.
Employment discrimination.
Sexual harassment sort of puts a bad taint on it, but
that's what it said in the complaint. Excuse me for reading.
I know, I don't like that.
Excuse me for being literal. I apologize.
Anyway, Judge, the Holly Hawkins was paid her $44,000.
Plus $45,000 in attorney fees.
Right. I think that was the
once that was resolved, and you piggybacked on that case, how then does your case remain under the civil procedure?
Well, at that point, or right before she was paid on her judgment, the cases were bifurcated. So our case, it wasn't severed necessarily, but it was bifurcated and sent off on its own.
Well, it may have been, but my point is, in essence, you piggybacked on her claim to get a large amount of money to pay her damages. She satisfied that. How then does your case remain as a third-party complaint?
Well, even if it couldn't remain as a third-party complaint, that was never raised by Cumulus, and it was still bifurcated, and it went through. No one ever raised this issue that someone's going to have to refile it, but it was bifurcated and sent off on its own as though there were two separate cases, and it was tried by itself. It was set for trial by itself.
Well, in the other case, wasn't there a refunding of the monies once the issue was raised after a short period of time? You owe us $300,000, and wasn't that paid?
The accounts receivable?
Yes, sir.
No, Your Honor. What they've done here is Cumulus has said that, alternatively, it said, number one, we paid that back.
Yes, sir.
But it was also used as consideration for the extension. Now, so they're speaking out of both sides of their mouth. They're saying, this wasn't our money, we gave it back to Southern, you should get it from Southern.
Right.
But on the other side of their mouth, they're saying, we used that money as consideration for an extension of the contract.
How different does it matter?
Well, because if it's not theirs, they can't use it as consideration. If it's not theirs, then they gave somebody nothing. And then that wouldn't be true.
But isn't that for Southern and its bankruptcy trustee to carp about?
Well, right now, there's an issue of fact about whether Cumulus actually gave money back to Southern thinking that it was Gem's money. It also had notice at that point that Gem made a claim on the money. So if Gem had made a claim and it was giving, it said, okay, if Cumulus was really admitting, we don't own these accounts receivable, Gem does, why give it to Southern? They already had notice that they owed somebody else this money that was in their possession. But that wasn't fleshed out in the trial court either.
Southern's supposed to act as the collection agent under the original contract for sale?
Southern was supposed to act as the collection agent to make sure that money got transferred, yes.
And didn't it get transferred?
No, it didn't get transferred. But there's a difference here, Judge, because there is first of all, the issue that you're raising here was not raised in the trial court by Cumulus, saying that they didn't really owe the money. But also they had notice of a third-party lien on the proceeds, or that money was actually owed to a third party. And at that point, they couldn't just pay it to the wrong person. They knew that contractually it had to go to Gem, but they went ahead and paid it to Southern anyway.
Based on an agreement to agree, isn't that what happened?
Excuse me?
Based on an agreement to agree, that is this purchase agreement.
The purchase agreement, yes. But now, if Cumulus was cognizant of the fact that it owed the money to Gem, How could it also pay that money to Southern by say that this was consideration for an extension of time on the contract? And that, at the very least, that presents a jury question where it has to go back to the jury, be presented, so the jury can decide which of those two stories is correct. If they really wanted to pay Gem, then the jury would find in favor of Cumulus. But if what they really did was to pay Southern in order to get an extension, and then they just called it the money that was owed to Gem.
But we're all talking, it's the accounts receivable. It's not like there was some other fund of money that they used or some independent investor.
Judge, money is fungible. It's just money. They said it was they gave a label. The amounts don't match up. They gave it a label. They say, we're going to pay this back to you because Gem is owed the money. And in exchange for that, you're going to give us an extension of time. Now, those two things legally do not add up. And at the very least, a jury should be presented with those two contrary statements and then decide which is it. Was it really consideration for the extension of time? Or was it a payment of Gem's accounts receivable so that Southern could then give the money to Gem? But also, Judge, I have to make sure that we're all clear that this issue that you're raising was never raised in the trial court. There has been no legal argument. There's been no evidence presented on this. The issue in the trial court was this good faith purchaser for value, which Cumulus certainly is not. They had all sorts of notice that this was owed to Gem. In fact, the issue you're raising is an assumption that they had notice that this money was owed to Gem and could not be good faith purchasers for value. If there is some other legal basis for the trial court to enter judgment, then that's something that would have to be raised by Cumulus and then ruled upon after it's been argued and presented to a jury. Maybe a summary judgment if the facts are argued and the point is raised. But at this point, it has not been raised.
Well, what troubles me is the findings by the special master specifically relating to this issue. And they said that you're not obligated, and therefore the monies were discharged properly and paid to the proper party. And the court held a separate hearing supplemental to the hearing of the special master and agreed and said, disagreed with your position that you have today. And you couple that with the fact that you piggyback into this case on a client or a litigant who has been paid, and there was a stipulation that I'm happy and I'm going away and my claim is going away. And then you said, well, there is still a jury issue. And it's on a motion for summary judgment where a hearing was held. The judge heard testimony. There was a special master who interviewed and held hearings, quite a number of them. And the judge entered an order after having an additional hearing.
The special master took the testimony, and the special master decided that decided an issue that was completely separate from the issue that the trial court decided. The trial court held a de novo hearing, and in the order granting the motion for summary judgment said after a de novo hearing and after reviewing the special master's findings, it then went through and said Gem is a good faith purchaser for value. That was not the finding by the special master. The special master said that the money should have been paid to Gem by Southern, and it was really paid. But that wasn't the finding by the trial court. The order that we're appealing is a final summary judgment entered in favor of Cumulus, finding that they are a good faith purchaser for value. And that is it. The issue on the subject matter jurisdiction, about the procedural niceties of this case, Judge Barlow said that this is not he wasn't sure that this is a subject matter jurisdiction issue. And then he went on and talked about good faith purchasers for value. That is the ruling from the trial court, is that they are a good faith purchaser for value. That is contrary to what the special master found.
Well, the facts that the special master laid out are not supporting the position that you have. And even though there was a hearing de novo, and going through that testimony, it is obvious that those facts were laid out presented to the special master, and a different conclusion reached in your position here today. I'm curious, where did Judge's ultimate disposition finding that bona fide purchases come from?
It came from the hearing that he had. There was a transcript, and there was a hearing that he had on the issue. It was a de novo hearing.
I mean, who raised it?
Who raised it?
Yes,
I don't recall, but I'm pretty sure it must have been Cumulus raising that issue. I doubt my clients raised it. I'll reserve the rest of my time for rebuttal. Thank you.
May it please the Court, my name is Mark Cooper, and I'm counsel for Cumulus Broadcasting, Inc. The appellant claims at page 1 of its initial brief that the judgment which is the subject of this appeal has its genesis in another lawsuit. Respectfully, that's incorrect. What the record shows is that Jim made a choice. They could have filed an independent lawsuit against Cumulus, asserting conversion and all the various claims that they asserted. But for whatever reason, they did not do that. They filed a third-party complaint, and in fact, later on, they filed an amended third-party complaint. There's no question from the record that Jim was proceeding under the third-party practice rule. And the third-party practice rule provides, it's Rule 1.180, that third-party practice applies either if there is an assertion for liability based upon all or part of the plaintiff's claim against the defendant, all or a part of Holly Hawkins.
The argument has been made that the court bifurcated Ms. Hawkins' issue, that hers went a separate way and it was resolved, and theirs stood alone. The problem is that if hers disappears, how then can theirs stand alone if they did not file a separate complaint based on the theories of recovery that they had?
I don't think they can stand alone, and I think the case at that point properly should have been resolved.
Did she satisfy her final judgment?
I'm sorry?
Did Holly Hawkins actually file a satisfaction of her final judgment?
I believe that she did, Your Honor.
And did that have
In fact, the leases were exchanged.
And did that have the effect of terminating the case?
Yes, it should have. It should have. So therefore, the only issue that's left in our assertion before this court is the claim that somehow we've waived this, that somehow we did not assert this claim as we should have, and that we're prevented from raising it now. And in fact, counsel has alluded to that this morning as well. And Your Honors, that's simply not consistent with the record. The record on appeal in this case at pages 1115 through 1119 contains the answer and affirmative defenses of Cumulus Broadcasting, Inc. to the first amended third-party action. Paragraphs 17 and 18, which is on the record on appeal at page 1118, states as follows, and I apologize, but a brief quote. Third-party defendant affirmatively alleges that third-party plaintiff has failed to state a cause of action against third-party defendant in that the amended third-party claim does not assert that Cumulus is or may be liable to Jim for all or a part of Hawkins' claim against Jim, nor does it assert any other claim that arises out of the transaction or occurrence set forth in Hawkins' claim against Jim. The next paragraph reads, paragraph 18, quote, third-party defendant affirmatively alleges that this court is without jurisdiction over it because Jim's claim does not assert that Cumulus is or may be liable to Jim for all or a part of Hawkins' claim against Jim, nor does it assert any other claim that arises out of the transactions described in Hawkins' claim against Jim. Close quote. Respectfully,
is your argument that there is no nexus separate and apart from Hawkins, and once she resolved the case, which she did by entry of a stipulation of amended final judgment in October, that case in essence was ended, and since there was no direct liability between the other parties, that they had no standing to continue?
That's precisely our position. I'd be happy to answer any other questions the court may have. Thank you.
Directing your attention to the page 573 of the record, the stipulation for entry of an amended final judgment, where Holly Hawkins resolved her case and in essence said, I'm happy, releases were exchanged and the case ended. How can your case stand separately on a 1.180 when the reason for you being there has been satisfied, the parties have been released and exchanged releases and gone about their business?
Judge, I don't have that record page with me. Do you know the date of the,
October the 1st, 2002.
October the 1st, 2002?
Yes, sir.
Judge, if that issue had been raised timely, as was required by the rules of procedure, that would have been 3 years before the statute of limitations would have run. The statute of limitations ran in May of 2005. Now, what Cumulus did in this case was to not raise these issues. If you are correct, and because this wasn't raised in the trial court, this has never been briefed.
Okay. It was raised in the pleadings. I mean, it was discussed and in the record. And so I'm troubled by the fact that instead of amending and separating yourself out from the Holly Hawkins complaint, which has now gone away because she's happy she's gone down the road with her money, you didn't. And so how then are you still a third party? Because it was based on her obligation to be paid.
Judge, at that point, our third-party complaint, I believe, was amended to increase the value above the $44,000. And that was never answered or objected to by Cumulus. Now, you are raising an issue that in 2002, I'm not sure, I'll take your word for it, obviously, that that's the date. But whatever the date is, it is before the statute of limitations. And what's happening here is that Jim is being caught it's in a catch-22.
Are you arguing that either they sandbagged you or there was bad lawyering and you missed the deadline?
No, Judge, I'm just saying it was waived.
Okay.
Any problem with this the procedural tactics taken here, the fact that the Holly Hawkins case was dismissed and this traveled on its own power, so to speak. If someone had raised it at that time, then Jim could have just refiled the case and continued. But the fact that it wasn't raised until many years later, after the statute of limitations ran, is the catch-22. They had an obligation to either raise the procedural problem or waive it, and they waived it.
By sitting on it and not notifying you that
Yes.
you should amend your complaint?
No, just by not objecting to the case going forward. They proceeded with this case as though everything was fine. They let it get set for trial. They had a hearing for special master, several hearings before special master. And then finally, we get to the point where they say, okay, now the statute of limitations has run. You have violated this rule of procedure, and therefore you can't have this claim as an independent. And Mr. Cooper said it again, said they could have filed as an independent action. Well, yes, that's true. Jim could have filed it as an independent action if someone had raised this issue prior to the statute of limitations running.
Didn't they raise it in the affirmative defenses?
No, they didn't, Judge. They did not respond to the amended complaint. The amended complaint made the claim up to $300,000. Cumulus never answered that complaint.
But this affirmative defense then preceded the filing of the amended complaint?
There was no affirmative defense, Judge.
Didn't I just hear him read that they affirmatively alleged and in effect quoted part of the rule to you in their plea?
Not in the pleadings, Judge. The first answer that was given by Cumulus raised substantive issues, did not raise the procedural issue that is being raised now.
Their obligation to tell you that you're in court on the wrong rule?
Why would they have that obligation? I don't understand that argument.
Well, Judge, any objection to procedure has to be raised in a timely manner. You can't just...
Let me ask you a question.
Where does it say that?
If a lawyer knows that a deadline is about to pass and litigates in the case, and it's your obligation to meet that deadline, is the lawyer obligated to notify you that if you don't file something, the statute will run?
No, Judge. What the lawyer is obligated to do is to present all the objections, affirmative defenses, et cetera, timely. By not answering the amended complaint, everything in there was admitted.
Okay.
Was there a prior answer to another complaint?
No, not that raised this issue.
You don't disagree, then, that had it been timely raised, you would have been required to amend your complaint?
I'll take that, yes, the judge
Well,
will
you
probably
have to,
should
because obviously-
file a separate lawsuit, probably.
That's exactly what I'm
Yeah, file a separate lawsuit. But Rule 1.250 says that misjoinder is not a grounds for dismissal.
Unless the statute has run and you're not eligible then
Yeah,
to
but
file your
if we
lawsuit.
can't, at that point, no, it just gets converted. It can't be dismissed and then refiled. The case is just severed, and then it becomes its own lawsuit. But there's no provision to just dismiss a misjoined case and then let the misjoinder have whatever effect it has. The rule of procedure is very clear that it says misjoinder is not grounds for dismissal. There are procedural problems. There's lots of issues with the procedure utilized in this case. But the fact that it was unusual does not make it legally proper to just dismiss the case or enter summary judgment and get rid of it at the late date that it was. Thank you.
Thank you, sir. We're going to take a short